Here in Idaho, the small victims' rights movement that happened here in Idaho started in the 60s with the Idaho Women's Commission. The Idaho Women's Commission were women who'd been appointed by the governor to educate women on their right to vote, to try and get more women out to vote. Well, the Idaho Women's Commission decided that wasn't good enough, and they actually created a book to educate women on all their legal rights, not just their right to vote, but their right to how they should be able, if they need a divorce, how do they get a divorce, what their rights are in terms of property and finances, and in terms of victims' rights. What are their rights concerning services that could be provided to them when they are a victim of crime. That started in the 1960s and actually continued on until the Idaho Women's Commission was disbanded 2 years ago. And it was disbanded because the powers that be said, well, we've met all the needs of women in the state, so we don't need the commission anymore. And so the commission was disbanded. In 1982, the Idaho Council on Domestic Violence and Victim Assistance was created. Remember when I talked about the Crime Victims Fund and how that money then goes to states and then states give it to individual programs? Well, when that money comes to Idaho, it goes to the Idaho Council on Victim Assistance. And the Idaho Council on Victim Assistance then receives applications from local programs around the state, and then they give the money. They're the agency here in the state that gets that money to the local level. The Idaho Crime Victim Compensation Program, they get that other chunk of money that comes from the Crime Victims Fund to do compensation work. In 1988, the state passed the Domestic Violence Prevention Act, and that was the first time in Idaho that there was the very first statute that said that domestic violence was illegal in the state of Idaho. There had been aggravated assault statutes and misdemeanor assault statutes on the books for decades, but they just they were never applied to domestic violence, and so it took a special statute in order for those crimes, those actions to be labeled as crimes if you were married or related to somebody. And then here in Idaho, unlike other states, in many other states, crime victims' rights are afforded by statutes. They're individual laws that are passed. Here in Idaho, crime victims have constitutional amendments, constitutional rights. The amendment was passed in 1994, so just like defendants have constitutional rights in the state of Idaho, victims have constitutional rights in the state of Idaho. And here's what those rights are. This is the amendment itself, and it says that obviously a crime victim gets to be treated with dignity. That's that dignity clause. And that a crime victim has the right to a timely disposition of the case. That they have a right, just like a defendant has a right, they should have a right to be taken into consideration in terms of how long is this case dragging on or how quickly is it happening. They have a right to be notified if there's going to be a court proceeding. They have a right to be told that a hearing is happening, and they have a right to be present at all those criminal justice proceedings. They have a right to communicate with the prosecutor. They have a right to talk to the prosecutor about their case and ask questions and have those questions answered. They have a right to be heard in terms of providing a statement. They have a right to give a statement anytime any of those things are going to happen: a plea of guilty, a sentencing, incarceration, or release. And they have a right to restitution. They have a right for the court to order restitution to be paid. Something that most crime victims still do not understand is that if you're a victim of a crime, you have the right to tell a defense attorney to go jump in the water. You have a right to not speak to people. And I think the average citizen doesn't know that if you are a victim of a crime and the defendant's attorney calls you, the average person, I think, believes that they have to talk to that person. It's not true. They have a right to refuse to be interviewed. And finally, victims have a right to read pre-sentence investigations. That generally has been held as a confidential document that exists between the pre-sentence investigator and the court, and then the prosecutor is allowed to read it, and the defense attorney is allowed to read it, and the offender is allowed to read it. This is still not a right afforded to everybody across the country. It's actually fairly unique to a handful of states that victims actually get to read the pre-sentence investigation. Although they're always interviewed everywhere in the country for the pre-sentence investigation, in many places they don't get to read it. And then lastly, when I started working in the field in '91, crime victims did not have rights in juvenile cases. So if you were a victim of a crime and your offender was a juvenile, it was just like the old days. You got nothing. I couldn't tell people anything. I couldn't tell them when a hearing was. I couldn't tell them what the disposition was or the adjudication was in that case. I couldn't tell them whether that juvenile was sent to a detention facility or whether they were released to their parents. I couldn't tell them anything. Not until about 1994, actually, at least for me in the state of Minnesota, was when the first time I could actually get a victim inside a juvenile court hearing so that they could see what was happening to their own case. Now, before I go there, about crime victims' rights. So an interesting thing just came up to me a couple weeks ago. There are times in the criminal justice system where mediation occurs. It's called criminal mediation. And so you will, a crime has occurred, someone's been charged, and they decide to try and mediate. So you would have a prosecutor in one room, you'd have the defense attorney and the defendant in another room, and you would have a mediator, oftentimes who is a judge, who would, or a retired judge, who goes back and forth between the rooms and mediates a resolution to a criminal case. This isn't a civil case, this is a criminal case, and mediates a resolution to a criminal case. I got a call from a reporter who was doing an article about criminal mediation, and said, I don't think crime victims are allowed in mediation sessions. And she said, and she wanted to know if I thought that was a problem. And so she told me that she had been told by a number of prosecutors and by a number of judges that victims are not afforded rights in criminal mediation. And so this, I guess, is now a hot topic since it apparently made the paper in Twin Falls. So the question is, that I'm going to ask you, is would a criminal mediation session be considered a criminal justice proceeding? How many people think a mediation session is a criminal justice proceeding? Okay, so about half, maybe a little bit more than half. Somebody who thinks it's a criminal justice proceeding, tell me why. Raise your hand. Tell me why.
Well, it's an adversarial approach to
Okay, it's an adversarial approach to solving a criminal issue. Okay? Anybody want to add to that? Yes.
I don't entirely agree with that statement, but what I would like to add is that if you do end up writing some sort of agreement in terms of restitution or something like that, then that can become legally binding if the parties agree that they were not under duress at the time that they made the agreement. So I would say that yes, it is, simply because it can be binding.
Okay, so because that proceeding may result in something that's legally binding, that would then mean it's a criminal justice proceeding. Okay? Now, somebody who doesn't think it's a criminal justice proceeding, come on. You may have been in the minority, but that's not a big deal. And this is an open question. Nobody's going to take it.
I'll give it a shot.
Okay.
I don't believe so because if you're just having a mediator in there, there's no real, even if he is a retired judge, I don't believe it's a criminal justice. Because it might be civil, but I don't believe it's, because if you're gonna go into mediation, then the defendant probably will not be charged for the crime, that's what the whole mediation is for. It's to decide, is he gonna be punished, or is he gonna have to actually put some sort of financial payment or something like that in place? And that all just falls into a civil contract. I don't think it's an official, like criminal justice proceeding like a court case would be.
Okay, so the fact that the mediation probably mimics or maybe comes to more of a civil kind of issue, and that it may even just revolve around whether someone is charged or not, that means it may not be a criminal justice proceeding. And I think those are all valid. Those are all valid comments. And the answer is nobody knows. I said my opinion was that if out of that mediation, a guilty plea, a sentencing of any kind, jail time of any kind, the release of a defendant, so maybe someone's being held and they're going to be released as a result of the mediation. If any of that occurs as a result of that mediation, it's a criminal justice proceeding per what the amendment says. If it doesn't, then I guess there's a case that it wouldn't be. A couple of retired Supreme Court judges are saying that it's not because the presiding judge in the criminal case isn't the one doing the mediating. That's their argument. So they're arguing by who is doing it. I'm arguing by the outcome of it. So my final response was just that was something that actually the only person who could decide that is the Attorney General's office. They're the ones that the arbiters of what laws really say and what they really mean in the state. And so I suggested she go to the Attorney General's office. And the Attorney General's office declined to comment. So all of us know the exact same answer to the question, which is we don't know. But criminal mediation has been used in homicide cases. They're used in felony level cases, and they're used in violent crime, and they're used in property crime. So they're not used often by any means. It could be 20 cases a year across the whole state that use criminal mediation. I don't know. But it was just an interesting thing that happened just coming into this whole week of sessions. All right, victim services. So victim services appear in several forms. You have community-based advocacy. So these are generally nonprofit organizations in the community that work with crime victims. Some of them specialize in domestic violence. Some of them specialize in sexual assault. Some specialize in child abuse. Some specialize in working with what we call general crime victims, which means that they fall into the much bigger category of all those other non-specialty kind of cases. And they receive funding from the council, just like everybody else does. And they serve people whether or not they report to the police. So to access those services at the community level, community-based advocacy services, you do not have to report to the police. That's not the same. That's not the situation with law enforcement-based victim witness or prosecution-based victim witness. So victim witness coordinators at the police department or prosecutor level are there to work as a liaison between the victim and police officers, the victim and prosecutors. They're there to educate victims on what their rights are concerning a police investigation of their crime. They're there to educate victims on what their rights are in terms of prosecution and trial proceedings for their case. They're usually there to provide emotional and moral support as well. And they, at the prosecution level, are usually there also to prep victims for testimony in their trial. But as you can probably guess, there are other differences. So to get victim witness services, you have to report, right? You don't get to have a victim witness coordinator with the police department unless you contact the police department. And you don't get to have a victim witness coordinator with a prosecutor's office unless your case is charged. But then the other difference is that when you are working with, if you're a victim and you're receiving services from a community-based program, they don't have anybody to answer to. In terms of, if I tell them something and I say, I really want to just keep that between us, they really can keep it between them unless they receive a subpoena, right? If a victim witness coordinator works for a police department and a victim says, hey, I'm going to tell you something, but I really need you to keep it confidential, can they? I see one person shaking their head back there. Why? Exactly. Because they work for law enforcement, they can't keep it confidential. They have to tell the investigator. If it's a victim witness coordinator who works for a prosecutor, they work for a prosecutor. They can't keep it confidential. That may be exculpatory evidence that needs to be turned over to the defense attorney and to the court. So the ability to maintain confidentiality is weakened at the victim witness coordinator level as opposed to a community-based advocate. That doesn't mean they do a bad job. It doesn't mean anything. That's not what I'm saying at all. It's not a judgment call. It's just a fact of where they work and who they work for. So victim witness coordinators have to be very careful in terms of what they allow victims to tell them, which is why it's also very important for victim witness coordinators and community-based advocates to have very good working relationships. That way, if a victim witness coordinator feels like the victim really needs to talk to somebody who isn't going to be under any sort of guideline to have to tell the system everything that they say, they want to be directing that person, you know, I really think you really need to be talking to a community-based advocate. Let me get you with somebody and you can talk with them, and that way we don't have to worry about it and there's no conflict of interest. And at the same token, community-based advocates need to have good working relationships with victim witness coordinators, because while they're providing services to a victim, that victim may decide that they want to report. And if they want to report, a community-based advocate needs to have a really good relationship with a victim witness coordinator in order to say, hey, I've got a victim who wants to report. Can we sit down? I want to introduce you to them. I want to be able to explain everything you're going to be able to provide for them, and then the two of us can work together to provide the best services possible. I would like to tell you that that's what happens all the time. It's not. It's really sad to say, but just like you see turf wars between police agencies for various reasons, you see turf wars between community-based advocates and victim witness coordinators for various reasons about whose victim is whose. And so that's just something that has come with the growth of services and the growth of programs, and so you get competition where there really shouldn't be competition. We also see very much infrequently, but we also see victim services at the corrections level. So probation offices or prisons may have victim witness coordinators to work as liaisons. And also now with PREA, with the prison reduction, the federal act that reducing prison sexual assaults, more victim services are being afforded to prisoners who are victims of sexual assault while they're being incarcerated. And then we have our state and national agencies. All right, I got 1 minute to tell you that a study has been done, a small study was done looking at what proportion of crime victims actually get services. And they looked from 1993 to 2009 and found that 9%. 9% of crime victims in this country receive services. Now, some of that is due to services not being available where crime victims are. That is also due to crime victims not knowing that there are services available to them. It's also due to crime victims not wanting services, not wanting to talk to people, not wanting to disclose, not wanting any assistance at all. So that it's a mixed bag, but 9% after all these decades of work, 9%. And the victims that are more likely to receive services, obviously those who report to police, because they have a built-in system right there with victim witness coordinators. Women, people who are victims of serious intimate partner violence, which is what we call domestic violence now. Victims of rape or sexual assault. People who lived in rural areas, which was a little shocking to me because we consider, as I said, people who live in rural areas to be underserved. And people who are injured. However, here's the thing. Those 9% who receive services, they're more likely to have contact with police, which means there's a greater likelihood that the offender is going to be brought to justice, right? It's going to be held accountable. They're more likely to have a case charged out, once again, holding the offender accountable. More likely to have an arrest made. That's all that work of the assistance from the victim witness coordinator. But they're also more likely to have contact with a non-law enforcement criminal justice professional. They're more likely to have contact with a court administrator or a judge or a prosecutor rather than just a police officer. So they are more likely to become involved with the criminal justice system the more they receive services.